Okay, we're not back on the record yet, but just wanted to let people know that the link seems to be repaired, and that if people want to connect to the YouTube link now, they have to close the old link and refresh their browser, and then get into the new link again. And it should be working. I just tried it and it seems to be working.
Thank you. This is Peter Gould. I will call my co-counsel, tell her to, you said turn it off and refresh and then get back on.
Right.
Thank you so much. Appreciate it.
Your Honor, I was able to confirm it is working here. So.
Good. Okay, is everyone comfortable going forward from here?
Staff is ready to proceed.
I'm ready, Judge.
Okay. Okay, let's go back on the record. When we stopped last, we were about to have Western Resource Advocates do their cross-examination. Ms. Beatles, you reserved 25 minutes.
Thank you, Your Honor. Good morning, Mr. Reynolds.
Morning, Ms. Peters.
My questions are going to relate to, let me just find the page number, page 16 of your testimony in opposition to the stipulation, just to give you a chance to get there if you so choose. So on page 16, you state that if the merger is approved, the sale of La Jolla Wind Farm Energy by Avangrid Renewables to PNM would become an affiliate transaction. Is that right?
Yes.
And the commission has a rule governing affiliate transactions. Is that right?
Yes.
And that rule, based on its citation numbering, is known as Rule 450. Is that right?
I believe so.
And Rule 450 incorporates the statutory definitions of Class 1 and 2 transactions, right?
I believe so.
And would you agree that the definition, the statutory definition of Class 1 transactions is the sale of goods and services by an affiliated interest to a utility? Is that right?
I'll accept what you're saying. I don't have the rule in front of me, but that sounds right.
Thank you. And commission rule, so that would make the sale of La Jolla Wind Farm Energy by Avangrid Renewables to PNM. If the merger is approved, that would make that a Class 1 transaction, right?
I suspect that's correct. Yes.
And Rule 450 requires utilities to report Class 1 transactions, right?
I believe so as well.
And the commission has the authority to investigate Class 1 transactions.
Yes.
The rule does not contain a prohibition against Class 1 transactions. Is that right?
That's correct.
Okay. I have no further questions. Thank you. That's all. Thank you, Mr. Reynolds.
Okay, the Attorney General, you've reserved 30 minutes.
Yes. Good morning. Good morning, John.
Who is speaking?
This is Kevin Gedko on behalf of the Office of the Attorney General.
Morning.
Good morning. I'm going to reference both the second amended stipulate, well, actually 3 documents, your direct testimony, and the testimony in opposition to the second amended stipulation, as well as the second amended stipulation. Beginning with your direct testimony on page 26, you express concerns, and this is a quote. I don't know if you want to get there or I can just read it for you.
There.
Okay, on lines 16 through 20, you express concerns, quote, about the non-utility activities of Avangrid Renewables in New Mexico and presence of Avangrid Renewables, which would be affiliated with PNM, would likely chill the competitive climate, correct?
Yes.
And then on page 27 of your direct testimony, when you are asked how to mitigate this concern, and now I'm on lines 7 through 12 of page 27, you state that staff initially proposes that Avangrid Renewable refrain from bidding on any future renewable energy or energy storage
Sorry,
developments.
Avangrid Renewable.
That Avangrid Renewable refrain from bidding on any future renewable energy or energy storage developments for 10 years. Alternatively, staff recommends that an independent evaluator accountable to the commission and paid for by Avangrid should review every PNM competitive procurement for renewable energy or energy storage in New Mexico, where any Avangrid subsidiary or affiliate is a bidder. Did I read that correctly, Mr. Reynolds?
You did.
Thank you. So then going to staff exhibit 5, which is your testimony in opposition to the second amended stipulation. On page 15, item 15, you reiterate staff support for this 10-year refrainment from bidding by Avangrid. I could read that, or you could just affirm that well, it says staff continues to believe that the cleanest approach is for Avangrid to
Sorry,
refrain.
you'll have to read that slower. It
Okay,
says,
sorry. Staff continues to believe that the cleanest approach is for Avangrid to refrain from bidding on renewable energy projects in New Mexico for an extended period. Did you see that, Mr. Reynolds?
I did.
So that's kind of the background. And then, so now, would you agree that one purpose of an RFP is to help competitively select the best resources to meet the needs of New Mexico's consumers? Perhaps?
Yes.
And throughout this hearing, we've heard about how those needs are reliable, clean, and low-cost energy provided to New Mexico's consumers. Would you agree that those are 3 factors that we'd be taking into account?
Yes.
So then I'm just going to propose a hypothetical. So if during a procurement process, let's just hypothetically, Avangrid Renewables could be out there and may be able to offer the lowest cost resources, assuming all else is equal, like reliability, cleanliness, any other factor equal. Hypothetically, holding all those equal, Avangrid Renewables may offer the lowest cost resources. And then let's assume that Avangrid is not permitted to bid on the proposal, like in the case where they must refrain from bidding for 10 years. Given those parameters, would PNM in that situation have the option to choose the lowest cost resources and therefore the best option for the consumers of New Mexico?
I would say under the hypothesis that you described, that if all those facts were in fact in place, then PNM would be choosing a project that would be more expensive than Avangrid's project, which, based on your hypothesis, would be the lowest cost project. There are a lot of factors that, all things being equal, is it's an unusual circumstance. But I recognize that if Avangrid was the cheapest and they were excluded from bidding, then the cheapest would effectively not be available. But as I also say in my testimony, having been a witness in many PNM renewable portfolio standard cases, that the market has been robust in New Mexico and has gotten increasingly robust over the years, especially since the passage of the Energy Transition Act. And so it's just not clear to me that in a robust market that one developer will consistently be the cheapest option. So I think the hypothesis is a stretch, but to the extent I accept it, now I accept your conclusion as well.
Thank you. It's a good answer, and it also kind of helps lead to my next question, which focuses a little bit more on the idea of having 10 years where Avangrid Renewables isn't allowed to bid. And now I guess we can kind of look at it in the context of this robust market that we're talking about already existing. And so if I go back to the quote that I already read, which was that staff initially proposes that Avangrid Renewable refrain from bidding on any future renewable energy or energy storage developments for 10 years. And then in the alternative, recommends that an independent evaluator be chosen. What we've seen in the stipulation is that it's been stipulated that there would be an independent evaluator. And I know in your testimony in opposition to the second amended stipulation, you've expressed reservations in that there's still the possibility of recovery from ratepayers for the use of that independent evaluator at times. And you've expressed a reservation that you feel that the commission should choose the independent evaluator. Is that correct?
Yes, it is.
If the independent evaluator, if the stipulation were accepted along with the current terms for what the independent evaluator's role is and who pays for him or her, would you want to maintain that Avangrid Renewables would be prohibited from bidding for 10 years if we were to accept the stipulation as is with respect to the independent evaluator?
I believe in my testimony, as you've stated, that my initial recommendation is for Avangrid to refrain from bidding for 10 years, but I've offered an alternative. The alternative is meant to replace my initial recommendation, not be complementary to my initial presentation. So just to be clear about that. So if based on the current, what is currently on the table, if I can put it that way, so what's been agreed to beyond the second amended stipulation, it does provide for the commission to select an independent evaluator instead of having PNM select the independent evaluator per the second amended stipulation. So I think that satisfies part of my recommendation. Now, I think I need to answer the second part of your question. Was that about cost recovery, or can you remind me?
No, maybe I wasn't clear enough. I'm just to make it a little bit clear, I'll go to your testimony in opposition to the second amended stipulation, and on page 14, line 12. And what I see being said here is your reservations with what's in the stipulation with respect to the independent evaluator. And so the stipulation provides for PNM to choose and retain an independent evaluator, while the IE would be retained on behalf of the commission. PNM's authority to select the independent evaluator is inconsistent with the goal of keeping the procurement as fair and competitive as possible. Staff is also opposed to allowing PNM to recover the reasonable costs of an independent evaluator from ratepayers in case neither Avangrid nor any of its affiliates participate in a given RFP. Where that puts me is understanding that though concessions have been made with respect to the independent evaluator, would it be correct to say that not all of your recommendations from your direct testimony have been adopted in the stipulation as it stands?
Correct. And that's also correct with respect to the specific recommendation.
So since not all of your recommendations have been accepted in that stipulation, it leaves us a little bit in a gray area where you are absolutely correct to point out in the alternative, if my recommendations aren't accepted, then in the alternative, if 10 years isn't accepted, then I would want an independent evaluator with these terms. And now what we've just seen is those terms aren't quite met, according to your testimony. And so given that foundation, my question goes to, if the stipulation were accepted as is, which doesn't include everything that you originally requested with respect to the independent evaluator, would you want to revert, should I say, to that there has to be 10 years where Avangrid Renewables can't bid, or is there some movement there? And now I'll make a compound question of, if there is, perhaps you could explain your thoughts on that.
We, along with other parties in this case, have made recommendations about how we think this proposed transaction should unfold, under what conditions, et cetera. So if the recommendations, let's say, are adopted in part, as you say here, with respect to the independent evaluator, that's better than if they're not adopted at all. My position is not that if it's adopted in part and not in whole, that the recommendation should revert back to my initial recommendation. This way I see this is that this is our recommendation for the commission to consider and to weigh in on, and to adopt, reject, or modify as the commission sees fit. So from this point forward, we are partly on board, but not totally on board. And these are arguments for why we think joint applicants should do more, and the commission gets to weigh in and decide. And of course, I respect that decision.
Excellent. Then just exploring that, and I like that idea of providing that information for the commission. Exploring that just a little bit further. If we go back to the original statement from the direct testimony of, your preferred methodology would be that Avangrid Renewables is prohibited from bidding for 10 years. Just kind of curious, do you have a sense of what harm would come if it's less than 10 years? And perhaps if you're able to speak to that, speak to it with respect to the robust competitive environment that we referred to a couple minutes ago is existing at this point in the state. Did I make that question clear enough?
I think so. I think you're asking me what harm would come from Avangrid refraining from bidding for 5 years instead of 10 years in a market that appears to be robust and should expect to remain robust. I don't know that 10 years is a magic number for me. It was meant to match the Avangrid's commitment of ownership of PNM, to match those 10 years, so that if they are, in some ways, it was a message to Avangrid that if they're committed and being a long-term owner, then they presumably would accept some restraint on what might appear to be anti-competitive for a certain number of years, as I originally stated, 10
Sorry, anti-competitive.
behavior for some period of time, such as 10 years or 5 years. I get your hypothesis that you spelled out earlier, but I think the market is robust. I don't think that Avangrid is one of the big players. I think they've said there was a handful of those, I believe, in Mr. Kump's testimony. So there's more than one, for sure. And so I'm not, I understand that 5 is not unreasonable. I suggested 10 for using the rationale I just pointed out about Avangrid's commitment of ownership, but I don't think 5 would be unreasonable either.
And just as a last little question on it, in your analysis, have you figured a way or to comprehend an amount of time beyond which there could be a point in time beyond which these protections would actually become a harm to the overall goal of facilitating competition? And I originally thought about it in terms of, beyond 10 years, did we cut it off there? Because now we're hurting the competition, and it's changed a little bit based off your last answer, and I see the flexibility. And so now my question is morphed a little bit more towards, is there a way to think about that? And if so, how do you think about at which point we would be harming ourselves by not allowing that competition to come into the market from Avangrid Renewables?
I would start by responding to your question by saying that if Avangrid is prevented from participating in the development of competitively sourced generation in New Mexico, and that would be deemed harmful to the market, then I would say the market is not robust. If the market is not robust without Avangrid, I don't think the market is robust, period. So I would, I think it's too much, it's too big of a step to say that Avangrid is so critical to the market being robust that Avangrid must be allowed to participate under any circumstances. If that were the case, Avangrid would have market power and that it could use to its benefit.
If I don't know whether just to move on, just one little, if we had 10 competitors in a market and then we introduced an 11th competitor that was competitive with those initial 10, just in a vacuous market, would we generally say that a market with 11 competitors would be a more competitive market than a market with 10?
Incrementally, I would agree, it's more competitive. But I think it would be marginally more competitive.
That's fair. That's very fair. I'm going to move on to my last topic then, and I just want to go to the stipulation, and if we go to item 35, which is on page 29 of 45. On that page, it's stated I'm sorry.
Pardon me for interrupting. I need to get the stipulation before me. Just a second. I need to grab a binder. Okay, are you referring me to a regulatory commitment? If so, which number?
I'm going to item 35, and that's on page 29 of 45. And yeah, the stipulated regulatory commitments.
Yes, I have that before me.
Great. So there it's stated that right at the top of number 35, that the joint applicants commit that PNM will implement policies with respect to existing and or potential future affiliate contracts that would accomplish the following. And then there's, I count 5 or 6 things listed there. One of them states any information that PNM provides to its affiliate with respect to any such RFP, including with respect to any extension of an existing PPA, such as through a repowering, must simultaneously be provided to all bidders. You see that there, and did I read it correctly?
I see it, and I agree with your reading.
And then another statement is, the fourth one down is no other non-public information about a competitive RFP, including with respect to any extension of an existing PPA, such as including with respect to any extension of an existing PPA, such as through a repowering, will be shared between PNM and affiliates at any time, unless as described in this paragraph. Did you see that, and did I read it correctly?
I see it, and I agree with your reading.
So do you and does staff support these provisions, which I read to establish that PNM affiliates will not receive information both in quality and in a matter of timing, I would say, because if given at a different time, the information is essentially different. Would you agree that staff supports provisions which establish that PNM affiliates will not receive information that other bidders do not receive?
No, I see these what you've been reading, and I think it's helpful. I'm not sure if it's I'm not sure how secure and how enforceable this is. I mean, Avangrid is talking about creating or bringing 150 jobs to Albuquerque. PNM would remain headquartered in Albuquerque. I think Mr. O'Connell said yesterday that he expects a lot of job position churn. I don't think that was his word, but there'll be a lot of changes personnel wise if the proposed transaction goes through. Related to this, related to San Juan decommissioning, et cetera. I think it's a difficult, I recognize that there's goodwill here to try to make sure this information is shared. And, but there's lots of ways for information to travel. And I think that, this is a challenging commitment to live up to, and a challenging commitment to challenge. But that's my general view about these commitments.
You have 5 minutes, Mr. Getko.
Thank you. So even if challenging though, am I correct to understand that the general goal of PNM not sharing information with affiliates that it doesn't share with other bidders is a goal that would be shared by staff and yourself? And
Yes, I share the goal. I just questioned to what extent it can be relied upon to for the purpose of this commitment.
so now I'm going to go back. I'm going to tie this a little bit in your direct testimony and I'm on page 27 of your direct testimony, lines 12 through 14. There's a recommendation that you provided. When you get there, you can let me know.
There.
And what it says is, any PNM competitive procurement proposal should affirmatively state whether any Avangrid subsidiary or affiliate intends to bid or not. Did I read that correctly?
You did?
And then I'm going to do what I've been doing, is follow through and go to the second amended stipulation to show the continuity. And so now going to your second amended stipulation, and now in item 15, which is on page 15, and I'll wait.
On page 15.
There's this statement. With respect to a statement at the outset of an RFP process that explicitly declares whether Iberdrola, Avangrid, or any of their affiliates intend to participate by submitting proposals, it appears that this matter is not addressed by the stipulation. Staff stands by this recommendation. Did I read that correctly?
Yes.
So what I understand there, just to restate it, is that at the outset of an RFP process, it should be declared whether any affiliate or Iberdrola or Avangrid intends to participate. Correct?
That's correct.
So that it leads to this question. If PNM has to make a statement at the outset of the RFP process that explicitly declares whether Iberdrola or Avangrid or an affiliate intend to participate in that RFP, wouldn't PNM need to be informed or have informed Iberdrola or Avangrid of what that RFP is going to be?
believe PNM would have to be informed, PNM would have to inform Avangrid of their plan to issue an RFP. I don't know if that is consistent or not with those sections of regulatory commitment 35.
And- and maybe I'll ask it from a little bit different angle is, if at the outset we have to know, it has to be a declaration of whether Avangrid is going to participate in that RFP or Avangrid Renewables, for example. Wouldn't Avangrid need to know certain information with respect to the RFP in order to make a statement to PNM as to whether they were going to participate in that RFP? And to have that information, wouldn't there have to be communication prior to the outset of the RFP between PNM and Avangrid?
Yeah, I agree with that.
And then isn't it normal that bidders receive RFP information, just general bidders now receive RFP information when the RFP is issued? Like a potential bidder is normally in the dark as to what's going to be contained in an RFP before the RFP is issued.
I believe that's correct.
So how would Avangrid, and this is a difficult question, I think, how would Avangrid be able to inform PNM of its intention to participate in a procurement at the outset if the stipulation establishes, and staff supports this proposition, that any information that PNM provides to its affiliate with respect to any such RFP must simultaneously be provided to all bidders?
You raise a good point, Mr. Gifko, and I don't disagree with it. And I don't disagree that there may be an inconsistency with the requirement I'm recommending, and that these elements of regulatory commitment 35, at this point, I don't know what the solution is to that.
Well, I appreciate you walking through it with me, because I think it's, like you said, it's good information for the commission to consider. And so
It is. Yeah, it is. I appreciate you raising the point.
And I won't take credit. Luckily, I'm working with a good team and learning how to work here in this industry. So that's all the questioning I have today, and I want to thank you for it. Thank you for your time.
Thank you.
Okay, next up is Mr. Haverly. You've reserved 30 minutes.
I'm sorry, Mr. Who?
Haverly.
Thank you, Mr. Hearing Examiner. Good morning, Mr. Reynolds. I'm Brian Haverly. I represent Avangrid and Iberdrola. How are you doing?
Good morning. I'm fine. I hope you're well.
I am. Thank you, sir. Mr. Reynolds, you testified that the second amended stipulation has addressed 11 of the 17 concerns staff has raised in this case. Is that correct?
Yes.
Okay. And I'd like to talk to you a little bit about the El Cabo wind farm, just to orient you.
About the which wind farm?
El Cabo, EL space CABO. Mr. Reynolds, you have testified in this case that Avangrid Renewables should have filed an application for approval of location and right-of-way determination in regard to El Cabo.
I'm sorry, right of way determination?
Yes, right-of-way width, WIDTH determination. Is that correct, Mr. Reynolds?
Yes, I believe it is. Yes.
And in your Exhibit 5, which is your July 6th 16 testimony in opposition to the second amended stipulation, page 19, you propose an alternative to a retroactive request for location control approval and right-of-way width determination. Is that correct?
Yes, it is.
And that alternative would be to have Avangrid agree to participate in an inquiry into whether El Cabo should have obtained approval previously, and to provide staff with information related to El Cabo's operating capacity and other information related to El Cabo, as well as to work with staff on ways to develop, clarify, and strengthen the commission's rules related to location control and right-of-way width determination. Is that correct?
Yes, that's correct.
And Mr. Reynolds, are you aware that joint applicants in Mr. Bob Kump's July 29th rebuttal testimony agreed to this alternative course of action?
Pardon me. I am aware of that.
Okay. So, Mr. Reynolds, would you agree with me that maybe we can say that we have 12 of your concerns addressed now?
Yes, we can say that.
Excellent. Thank you. Mr. Reynolds, I believe that in your July 16th testimony, you brought up concerns about Avangrid and Iberdrola following established protocols of regulatory conduct at the PRC. Is that correct?
That's correct.
Okay. And that you, on page 21 of that same testimony, lines 4 through 8, you testified that if these regulatory protocols were addressed correctly, these breaches of established regulatory protocols were addressed correctly, it may mitigate some of staff's concerns that underlie a recommendation for an independent PNM board of directors. Is that correct?
That is what I testified to, yes.
Mr. Reynolds, are you aware that in his July 29th rebuttal testimony, Mr. Pedro Azagra Blasquez committed that joint applicants would abide by protocols that you referenced, in that regulatory counsel would be notified anytime there is a request for a principal to principal communication?
I'm sorry, you're breaking up. A request for?
That there would be a notification to regulatory councils of parties anytime there would be a request for a communication from or between principals of parties involved in a regulatory proceeding?
I'm aware of Mr. Kump's testimony to that effect, yes.
I'd like to talk a little bit with you about economic development, Mr. Reynolds. Staff is supportive of economic development in New Mexico, correct?
Yes, staff is supportive of economic development in New Mexico, and I think that's that support is spelled out in our testimony in this case.
And you believe that economic development provides benefits to the citizens of New Mexico, is that correct?
I do.
And you understand that joint applicants are committing to bring or create 150 new jobs to New Mexico, is that correct?
I do understand that.
And staff is supportive of joint applicants bringing or creating 150 new jobs to New Mexico, is that correct?
The staff welcomes the creation or bringing of jobs to New Mexico by Avangrid.
And Mr. Reynolds, you recognize in your testimony, Staff Exhibit 5, that new jobs promote additional job creation. Isn't that correct?
Yes, I don't disagree conceptually with the point Avangrid is making, that jobs have a multiplier effect that end up in further jobs. There are direct benefits from jobs, and there are indirect benefits or multiplier benefits from the initial set of jobs. And so my point about that sentence that you just referred to is that economic development contributions that result in jobs, that those jobs will likely result in indirect or multiplier jobs, just like Avangrid's 150 jobs, Avangrid's or PNM's 150 jobs would.
Thank you for that explanation. Mr. Reynolds, is the ultimate goal of economic development to bring new jobs to New Mexico or create new jobs in New Mexico?
I think the goal is to of economic development contributions is to incentivize or spur economic development opportunities and growth that will result in additional jobs.
Okay, so the end goal of economic development, you would agree with me, is new jobs in New Mexico.
Yeah, I'd agree that is, I'm not sure I would call it the end goal, but I think economic opportunity that results in new jobs. That's how I would phrase it.
Fair enough. Mr. Reynolds, are you aware of any economic development agency or group in New Mexico that guarantees that if you provide money to them, that they can provide a set number of new jobs in New Mexico?
I'm not.
So, Mr. Reynolds, wouldn't it be better to have a guaranteed new job rather than a promise to spend money that might not create new jobs?
I don't disagree with the premise of your question, but I don't believe that's the choice before us in this case.
Okay, did you hear Mr. Zagra Blasquez testify on the 11th, Mr. Reynolds?
I heard a substantial portion of his testimony, yes.
Did you hear him testify to the effect that without this merger that that Avangrid would not necessarily bring additional economic development outside of just the development of renewable energy resources within the state?
I don't recall any statement to the effect that the jobs would be beyond, could be beyond just renewable energy. I mean, of the 150 jobs, first of all, include up to 20 for PNM. So clearly those are related to energy, renewable or otherwise. The other 130, if you're saying some of those may not be related to renewable energy, I don't recall his making a statement to that effect.
And just to clarify, Mr. Reynolds, I wouldn't say they wouldn't be part of renewable energy. I was saying that they would not be in addition to the jobs that it would take to create a renewable energy project in New Mexico, like wind farm or a solar plant of some sort. That was just to clarify. So do you remember anything like that?
Kind of. Now you're saying they would not be related to, for example, the construction jobs related to building renewable energy generation that Avangrid may develop in New Mexico?
Correct. That's what I'm referring to, is that these new jobs would be in addition to any type of renewable project created in New Mexico.
I do recall that. And I do recall that because there have been instances in other cases where arguments have been made that the development of renewable energy resources contributes to the development of jobs to build those resources. And so I do recall that contrast in my mind about the arguments that Avangrid was making were different than the others that I've recalled have been made before the commission.
Okay, thank you. Mr. Reynolds, I'm going to move on to a different topic. I would like to talk a little bit about you, or talk with you, I apologize, about governance and management. I believe on page 9 of your rebuttal testimony, or that you state that maybe it's not your rebuttal testimony, actually, I think it's Exhibit 5, which is your testimony in opposition to the stipulation. It is simply inconceivable to me that the joint applicants are seeking the commission's approval for the proposed transaction, but are not willing to consider governance alternatives that would preserve at least some of PNM's current independence. Is that a correct statement?
I'm sorry, governance alternatives that would,
Preserve at least some of PNM's current independence. Is that an accurate rendition of your statement, Mr. Reynolds?
Yes, it is.
Okay. And you know, Mr. Reynolds, that PNM is currently owned 100% by PNM Resources, Inc.
I do know that.
Okay. And do you know that the entire board of directors at PNM, the utility, is comprised of PNM employees?
I do not know that.
Okay. Are you aware that whether there are any independent directors currently on PNM's board of directors?
I'm not aware of the existence of independent directors on PNM's board of directors.
Okay, so PNM doesn't currently enjoy independence on the board of directors. Is that a fair statement?
With respect to PNM specifically, that's correct.
Okay. And joint applicants are agreeing to have 3 out of 7 members of PNM's board of directors be independent directors if the merger is approved. Is that correct?
I believe that's where things stand at this point in the case, that the joint applicants have offered proposing a board structure of 3 independent directors and 4 non-independent directors.
And Mr. Reynolds, are you also aware that the joint applicants have agreed that the 3 independent directors will have special authority over board and officer compensation at PNM?
I'm aware of that.
And are you aware that the joint applicants are agreeing that the independent directors will have authority over the dividend policy at PNM?
I am aware of that.
And Mr. Reynolds, are you aware that the joint applicants are agreeing that the independent directors will have authority over the issuance of dividends at PNM?
I am aware of that.
So, Mr. Reynolds, you would agree with me then that joint applicants are actually proposing more independence at PNM than what currently exists. Would you not?
I would agree with that, but I would elaborate by saying that PNM's board post-merger relative to PNM's board currently, and those are not directly comparable in the sense that currently PNM's board is what you describe it to be, but it is under PNM Resources Board, which is a more varied board in terms of its directors. I don't know the precise mix, but my understanding is that there are a mix of dependent and non-independent directors there. And PNM is a major element of PNM Resources. And post-merger, PNM board would be under Avangrid Networks, I believe. which I don't believe has any independent directors. So I think the situations are not entirely comparable.
So you're not aware that Avangrid Networks has independent members on their board of directors, Mr. Reynolds?
Not that I recall, but I'd have to check.
Okay, that's fine. And Mr. Reynolds, the independent board of directors at PNMR, they determined that it would be in the best interest of PNM Resources and its shareholders and its subsidiaries to merge with Avangrid Inc. Isn't that correct?
They did, and it was supported by the shareholders. So I understand that. And that's why my testimony in this case largely focuses on other benefits besides those to shareholders.
Let's talk a little bit about the La Jolla wind farm, Mr. Reynolds. You request in your testimony that the commission require Avangrid to divest the La Jolla wind farm. Is that correct?
Generally, yes. I've modified that to some extent between my direct testimony and my testimony in opposition. I can go over the details, but you're generally correct.
Okay. And the reason for that position is that you believe that there is a perception of self-dealing at the potential expense of ratepayers. Is that correct?
Yes.
Okay. And you understand that there is a purchase power agreement currently in place between La Jolla and PNM?
Yes, I believe there are two purchase power agreements. It was done in two stages. There was the initial purchase power agreement that was reached subject to pursuant to the results of a RFP conducted by Facebook. And then there was a subsequent purchase power agreement that was result of a different RFP, subsequent RFP that was conducted by PNM.
Okay. And Mr. Reynolds, are you aware that those purchase power agreements were approved by the commission?
Oh, yes, I'm aware of that.
And do you remember when that approval took place, Mr. Reynolds?
I'd have to check in my testimony, but it was. I don't recall precisely. It's around 2018, I think, in one case, and 2019 or 2020, possibly for the next one.
And Mr. Reynolds, the joint applicants have committed. Well, let me strike that. Let me ask you this. Are you aware, Mr. Reynolds, that the joint applicants have committed that any extension or modification of the purchase power agreements between PNM and La Jolla would be subject to the review of an independent evaluator?
I'm aware of.
Mr. Reynolds, are you aware that the Federal Energy Regulatory Commission on June 23rd, 2021 issued an order authorizing La Jolla to make contract specific sales at market-based rates to PNM? I believe you're on mute, Mr. Reynolds.
Beg your pardon. I was disconnected.
Oh,
Long,
sorry.
a few seconds, but I think you were asking me about the FERC decision concerning La Jolla.
You are correct. Do you want me to repeat it, or did you think you heard the question?
I'll answer it, assuming I heard the question correctly. I'm aware of the FERC decision that was brought to my attention in, I think it was in, I can't remember whose testimony, but somebody from PNM or the joint applicants testified to it in rebuttal to the testimony in opposition.
Mr. Reynolds, are you aware that the FERC determination required evidence at the FERC that the joint applicants demonstrate that the affiliate sales would be above suspicion?
Not aware of that specific language, no.
Mr. Reynolds, do you think that the commission should take into account the fact that the FERC has already determined that there are no concerns about self-dealing between Avangrid Renewables La Jolla project and PNM when they evaluate this merger?
The short answer is yes. And a more complete answer is that I'm not preventing the commission from considering whatever the FERC decided or other circumstances in this matter. I mean, in my modified recommendation, my most recent recommendation, I'm proposing that Avangrid commit to divesting of La Jolla by, I think, by the end of 2024, but that they, unless they are relieved of their obligation by seeking such relief in PNM's renewable portfolio standard case to be filed in 2023. So that the commission could certainly consider, is certainly welcome to consider FERC's decision at that point in time.
Mr. Reynolds, are you aware that if the merger occurs, any future PPA or a change to any existing PPA between PNM and an Avangrid affiliate will require both the approval of the commission and FERC?
I am not entirely, now I recognize that FERC has issued a ruling concerning the La Jolla PPA, but I am not aware that, if I understood your question, that FERC approves all PPAs or any modification to PPAs that I'm not aware of.
Okay. Just assuming with me for a second, if FERC does have a required review process for PPAs and the PRC has a required process for PPA approval, and there has to be an independent evaluator that is involved in any agreement where Avangrid bids or an affiliate of Avangrid bids to provide power to PNM. Would you agree with me that that's quite a bit of review for those types of transactions?
I'm not sure. I question the depth of FERC's reviews because if relative to review by the PRC, which affects, which is more local, and there would be far fewer of those. I mean, if FERC reviews all PPAs across the country, that's a monumental task. And maybe FERC has wherewithal to do that, but I'm not that familiar with the details of the amount of work that is. But I think the PPAs that are relevant to the PRC in New Mexico affect New Mexico ratepayers, and that I think the commission has the Public Regulation Commission has a significant interest in those to the extent it impacts the ratepayers in New Mexico. So I think the PRC's examination of such matters is, I suspect, likely to be much more.
I'm sorry, sir, you're breaking up.
Yeah, the PRC's oversight is likely to be more intense.
I'm sorry, sir, you're still breaking up.
I'm sorry, there's outside background noise. I beg your pardon. The PRC's oversight over PPAs is likely to be quite a bit more intense than the FERC's oversight of the same PPAs.
You have 5 minutes, Mr. Haverly.
Thank you, Mr. Hearing Examiner. Mr. Reynolds, I have no further questions. Thank you very much for your testimony. I appreciate it.
Thank you.
Okay, let's take a break. Take a recess until 11:15, and then we'll move on to PNM's cross-examination. So,
Mr. Hearing Examiner, I have no cross, so.
oh, you have no cross, okay. Well, let's take a break. Well, and then we'll come back at 11:15 for redirect.
Thank you.
Forty-eight hours.
And we're off the record, but I just wanted to put everyone on notice, I guess, in particular, the city of Albuquerque, that Mr. Blank, Dr. Blank would be the next witness up after this redirect. So I don't know if anyone's still on, but next witness will be Dr. Blank.
Thank you, Hearing Examiner Schnauer. I'm calling him now to make sure he logs in. He has the Zoom link.
Okay, good. Thank you.
You're welcome. Thank you.
I'm ready, Judge.
Okay, thank you, David. Mr. Borman, go ahead with your redirect.
Thank you, Mr. Hearing Examiner. Mr. Reynolds, I think you're going to need to take yourself off of mute. Thanks. Real briefly, Mr. Gedko asked a question: if 11th competitor were added to a 10 competitor market, whether that would make the market more competitive. Do you remember that question and line of questions?
I do.
Okay. Wouldn't the answer to that question depend on who the 10 competitors were and who the 11th competitor was? I think we might have lost him.
Are you hearing me?
Yeah, I can hear you. I can't see you. There you are. Oh, there you are. All right. Did you hear my question?
I believe so. You asked me whether the nature of the 10 competitors would have an impact on the analysis of the impact of adding an 11th competitor.
Yes, and the nature of the 11th competitor as well.
Understood. Yes, I agree that an analysis of the field of 10 competitors and the additional 11th competitors would be helpful to would be very useful to determine the impact of adding the 11th competitor.
And so to solidify this, if you had, say, 10 mom and pop hardware stores in a community and a large nationwide chain moved there to become the 11th competitor, is it possible that that might not make the market more competitive?
Is it possible that the impact would be minimal, the way it based on your hypothesis?
Well, not just minimal, but it might make it less competitive, might it not?
I mean, it's conceivable that, you know, the nature of the 11th competitor could diminish the influence of the existing 10 competitors. And I suppose you could, to make a very broad analogy, if Walmart moves into town on the outskirts of town near the freeway, it's likely to have an impact on the mom and pop businesses that are downtown.
Okay. And now Mr. Haverly asked you some questions about the independence of PNM's board. Do you remember that?
I do.
And I'm sure Mr. Haverly will object to correct me if I'm misstating this, but I think he at least attempted to establish that the PNM board is not independent from PNMR. And I think at least as part of your answer, you indicated that PNM is a large component of PNMR. Do you recall making that statement?
Yes.
Okay. Do you know how many of the board members of PNMR are independent?
I do not know at this time, no.
Okay. Thank you. I don't have any additional questions.
Okay, thank you. Thank you, Mr. Reynolds, for your testimony. You're excused.
Thank you.
Okay, Ms. Yee, would you call your witness?
Good morning, hearing examiner Schnauer. Good morning, parties. City of Albuquerque calls Dr. Larry Blank.
Dr. Blank, would you raise your right hand? You solemnly swear the testimony you're about to give in the matter of opinion to be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Dr.
Thank-
Blank, oh, sorry, Mr. Lee. Dr. Blank, would you please state your name for the record?
My name is Larry Blank.
Do you have in front of you what has been marked City of Albuquerque Exhibit 1 for identification purposes?
Yes, I do.
And what is it?
It is my pre-filed direct testimony of Larry Blank on behalf of the City of Albuquerque dated April 2nd, 2021.
Did you prepare that testimony or was it prepared under your supervision?
Yes,
And are the answers to the questions that are listed in your testimony true and accurate?
yes,
Do you adopt this testimony today as your testimony in this proceeding, in this hearing?
yes, I do.
Oh, and by the way, do you have any corrections to that testimony?
No, I do not.
Your Honor, I tender City of Albuquerque Exhibit 1 for the evidentiary record in this case.
Is there any objection? Hearing no objection, City of Albuquerque Exhibit 1 is admitted.
Your Honor, I pass the witness.
Okay. Ms. Winter, the Water Authority has reserved 10 minutes.
No questions for Dr. Blank, Mr. Examiner.
Okay. Mr. Albright, you reserved 10 minutes.
Yes, Mr. Hearing Examiner, that's correct. Good morning, Dr. Blank.
Good morning, sir.
Jeff Albright, representing the Bernalillo County in this proceeding. I think the last involvement we had was with the Solar Direct project, as I recall, Dr. Blank.
That's probably true. Yes.
So I just have a few questions that I want to run through, and just to confirm, this was the only testimony that was filed. You didn't subsequently file any testimony in response to the Second Amendment. Is that correct?
That's correct.
And the position of the county right now is that they are not a signatory at this point, correct? To the stipulation.
You may want to restate your question. You use the term county.
I'm sorry. That was an error on my part. The city is not a signatory at this point to the Second Amended stipulation, correct?
That is correct.
Okay. So with, I would like to turn to page 4. And you list a number of jurisdictions in which you have provided written testimony. Do you see that in lines basically 4 through 6 on that page?
Yes.
Okay, so in those proceedings, have you encountered a situation where there has been independent evaluators used? I'm talking about independent evaluators, just to be clear, I'm talking about independent evaluators used in the RFP process. In solicit.
I don't recall. So I'm not saying no, because there's a chance that one of these jurisdictions perhaps does use independent evaluators, but I'm not recalling any.
Okay, fair enough. And in this proceeding, you're aware of the proposal that's been put forward by Bernalillo County with regard to an independent evaluator being selected or being identified by PNM, but selected by the commission, by the PRC commission from that list. Are you familiar with that general proposal?
I'm generally familiar with that, yes.
Okay, do you think that would have a positive effect or have a chilling effect with regard to participation by other potential bidders in an RFP process?
Are you asking, would the presence of an independent evaluator stifle participation?
Yes, where the independent evaluator was chosen by the commission from a list of independent evaluators proposed by PNM.
I don't think that would, it's not clear what you're comparing it to. In other words, I'm not sure what alternative you're comparing that to, I guess, versus perhaps PNM selecting the independent evaluator. But moving to a commission selected independent evaluator, I don't see how that would stifle participation.
Okay, let me present the three alternatives. So the three situations we would have would be one where PNM chooses an independent evaluator on their own, and that person is chosen to evaluate the RFPs that are submitted. The second, which is before the commission right now, or being proposed by the county, would be to have an independent evaluator from a list proposed by PNM. And the commission would make the decision among, let's say, 3 or 4 independent evaluators as to which one would act as the independent evaluator in a certain RFP. The third proposal would be that PNM does not choose it at all, and that it would be chosen strictly by the commission and paid for by the commission or through some other means other than PNM. And so my question is related to the second situation where you have several independent evaluators from a list. The independent evaluator is paid for by PNM, and the commission selects the independent evaluator from that group proposed by PNM. And so my question is, among those 3 alternatives, do you think that is a viable alternative or a viable compromise with regard to the role of the independent evaluator? And would it produce any chilling effect?
I think that is certainly one approach that could be implemented. So it is a viable approach. Would it somehow deter participation? Again, no. And in fact, it could bring greater assurance, that is having the commission or commission staff involved in that selection process could bring greater assurance to the competitive market that that this would be a more level playing field. Now, I want to be clear that I have not recommended the use of an independent evaluator.
Understood. Thank you. Thank you for that answer. And apologize that I had to go through so many iterations, but obviously there's a number of options there, so I appreciate that. You comment on page 7, bottom of page 6, leading to page 7 with regard to the vertical market power by leveraging the monopoly power of the utility.
I'm sorry, leading to page 7.
Yes, continuing to page 7, where an attempt to enhance, that this merger as possible attempt to enhance vertical market power by leveraging the monopoly power of the utility into the developing upstream competitive renewable energy market in New Mexico. Do you see that, Dr.
Yes.
Blank? Okay.
Yes.
When you talk about vertical market power, are you talking about the vertically integrated PNM system, or are you talking with respect to affiliates and what you refer to as the monopsony issue that would be provided by Avangrid and the affiliates?
Yes, I'm referring to the vertical relationship between an affiliate and the monopoly utility company. And the vertical market power concern arises because of that vertical relationship. If the competitive affiliate is allowed to participate in sales to the monopoly utility.
And is that related on page 11 of your testimony, if you'll turn to that?
2 minutes, Mr. Albright.
Thank you, Mr. Hearing Examiner. Is that related somehow to what you referred to at lines 18 through 22 with regard to the gold plating that might occur?
That is one concern. Specifically, the gold plating is referring to the sale of equipment, possibly from an affiliate to the utility company. We need to be concerned regarding the possible overpricing of that equipment. But that's only one concern.
But don't you think an independent evaluator would eliminate that or should eliminate that?
Well, I think the competitive bid process helps to mitigate that concern if the competitive bid process also applies to the utility purchases of equipment. And the addition of an independent evaluator also would help to mitigate the concern. But it doesn't remove the anti-competitive concerns that I have emphasized in my testimony.
Okay, Mr. Schonauer, that's all the questions I have for Dr. Blank. So Dr. Blank, as usual, thank you for your answers and your insight.
Thank you, sir.
Okay, next up is WRA. Ms. Beatles, you reserve 10 minutes.
I have no questions this morning. Thank you.
Okay. Mr. Haverly, you reserve 10 minutes.
One quick question, Your Honor. Dr. Blank, my name is Brian Haverly. I represent Avangrid and Iberdrola. Good morning. How are you doing today?
Good morning, sir.
Good morning. Dr. Blank, you did not file any testimony in relationship to the Second Amendment stipulation. Is that correct?
That is correct.
Excellent. No more questions. Thank you, Your Honor.
Okay. Dr. Blank, I just have one question for you. In your answer to a question from Mr. Albright, you indicated that you did not recommend the use of an independent evaluator in the RFP process for the procurement of new resources. Are you opposed to the use of an independent evaluator for that purpose?
I'm not opposed to the use of an independent evaluator, but I am opposed to allowing participation from an affiliate. So you could still have an independent evaluator monitoring the competitive bid process. It is the presence of the affiliate where I have concern. Now, on this question, Mr. Hearing Examiner, I probably should state that the City of Albuquerque has taken no position on the stipulations that have been filed.
Well, I just want to try to get clear, if I can, if is it your belief that an independent evaluator would be ineffective at preventing any anti-competitive impacts from the situation where an Avangrid affiliate might bid on a PNM project?
I think the independent evaluator serves to help mitigate the concerns, but there are other ways in which an affiliate may be able to gain some advantage. I could give you an example. The drafting of the RFP itself. As I understand the stipulation that's before you and the commission, the independent evaluator has no role in the design of the RFP in terms of technology that they are seeking, in terms of size, and other characteristics that because of PNM's future affiliation with Avangrid could potentially give an advantage to Avangrid in the design of the RFP itself.
Okay, that's all I have. Ms. Yee, do you have any redirect?
No redirect, Your Honor. Thank you.
Okay. All right. Well, thank you, Dr. Blank. Thank you for being flexible, and you're excused.
Yes, thank you, sir.
Okay. Well, let's continue. Mr. Albright, did you want to say something? No? Ms. Winter, is your witness available now?
Mr. Examiner, Mr. Garrett is logging in now.
Okay, great. Thank you.
Mr. Herringzammer, this is Brian. Sorry, Mr. Lee. This is Brian Haberly. I have a quick question. For this one witness, it may be most efficient if you would allow me to go out of order and go right behind Mr. Albright in my questions. And I believe that WRA, the AG, and CCAE are okay if I start before them. But if I get my questions done, it may make things a little bit more efficient for the others.
If the others don't object, that's fine with me.
Mr. Examiner, the Water Authority has no objection to.
Who is speaking?
I'm sorry, Mr. Lee. Nan Winter for the Water Authority. The Water Authority has no objection to a rearrangement of the cross witnesses.
Mr. Haverly, what was your proposed order?
I would go right after you, Mr. Albright.
I don't have any objection with that.
Okay. I don't hear any objection from any of the people who are being passed over, so to speak. So that will accommodate that. So Ms. Winter, call your witness.
The Water Authority would call Mr. Mark Garrett. Mr. Lee, can you do the honors?
Yes, Mr. Garrett, would you raise your right hand, please? Solemnly swear the testimony you're about to give in the matter not pending should be the truth, whole truth, and nothing but the truth.
Mr. Garrett, you're going to have to unmute.
Trying to. I did.
All right.
Sorry.
No problem. Can you please state your name and spell your last name for the court reporter?
My name is Mark E. Garrett, Garrett.
And your business address, Mr. Garrett?
4028 Oakdale Farm Circle, Edmond, Oklahoma.
And on whose behalf are you appearing here today?
On behalf of the Water Authority.
The Albuquerque Bernalillo County Water Utility Authority?
Yes.
It's a bit of a mouthful, I apologize. Have you filed testimony in this proceeding?
I have.
And you have in front of you what has been marked as ABCWUA Exhibit 1.
Yes, I do.
Can you please describe that for the record?
Yes, that is my direct testimony in this case filed on April 2nd, 2021.
And did you cause this testimony to be filed in this docket?
I did.
And did you prepare this testimony or cause the preparation of this testimony?
Yes.
Do you have any edits or corrections to this testimony?
No.
Did you say no?
No.
Okay, thank
Can
you.
you hear me okay?
Yes.
Okay.
If I asked you these questions today, would your answers still be the same?
They would.
And to the best of your knowledge, those answers are true and correct?
Yes.
Thank you. Mr. Examiner, the Water Authority would offer ABCWUA Exhibit 1.
Any objection? Hearing no objection, ABCWA Exhibit 1 is admitted.
Thank you. Mr. Garrett, do you have in front of you what has been marked as ABCWA Exhibit 2?
Yes, I do.
And can you describe that for the record?
That is my rebuttal testimony filed on April 21st, 2021.
And did you cause this testimony to be filed in this docket?
Yes, I did.
And did you prepare this testimony or cause it to be prepared on your behalf?
Yes.
Do you have any edits or corrections to ABCWA Exhibit 2?
I do not.
If I asked you these questions today, would your answers still be the same?
They would.
And those answers are true and correct to the best of your knowledge?
Yes.
The Water Authority offers ABCWUA Exhibit 2.
Any objections? Hearing none, ABCWUA Exhibit 2 is admitted.
All right, Mr. Garrett, do you have in front of you what has been marked ABCWA Exhibit 3?
Yes, I do.
And can you describe that for the record, please?
That is my testimony in opposition to the second amended stipulation filed on July 16th, 2021.
And did you cause this testimony to be filed in this docket?
Yes, I did.
And did you prepare this testimony or cause it to be prepared on your behalf?
Yes, I did.
And do you have any edits or corrections to that testimony?
No, I do not.
If I asked you these questions today, would your answers still be the same?
Yes, they would.
And are those answers true and correct to the best of your knowledge?
Yes.
The Water Authority would offer ABCWA Exhibit 3.
Any objections? Hearing no objections, ABCWUA Exhibit 3 is admitted.
Mr. Examiner, I have two other exhibits that joint applicants are willing to stipulate in. And that would be what was uploaded as ABCWA Exhibit 7, PNM 16th Revised Rate 20, and uploaded as ABCWA Exhibit 8, the January 2021 definitive proxy statement. The Water Authority would offer those two exhibits at this time as well.
Is there any objection to those exhibits? Hearing no objection, ABCWUA Exhibit 7 and ABCWUA Exhibit 8 are admitted.
The Water Authority passes the witness.
Okay. Mr. Albright, you reserved 15 minutes.
Yes, I'm sorry. Just needed to check my own list there. Good morning, Mr. Garrett.
Good morning.
Jeff Albright with J. Albright Law LLC, and I'm here on behalf of the county. I want to thank you for your flexibility as well with regard to this schedule and accommodating all of this. I'm going to primarily be focusing on ABCWA Exhibit 2 and Exhibit 3, just for reference. So that may help a little bit with this. I did have a question as to subsequent to your submission of July 16, 2021, are you aware of additional representations? Let me change that. Are you aware of additional discussions between the joint applicants and ABCWA with regard to some additional proposed changes to the joint application with regard to things like rate credits and so forth?
I am. I'm aware, but I did not participate in those discussions.
Thank you. And I'm not asking for details. I'm just asking if you're aware of those. Are you aware of the representations made by Mr. Blasquez with regard to potential changes that were reflected in his testimony?
Yes.
And do you have any objections to those proposed changes?
The changes that in his testimony that he made on the stand last week?
Correct.
Yeah, no objections to that.
Okay. Have you read Ms. Reno's testimony that was filed in this on July 16th with respect to the second amended stipulation?
I read it when it was filed. So it's been a little while.
I won't dwell on specifics, but generally those involved an increase in rate credits, some additional rate relief, some economic development. Do you recall those in general?
Yes, I do.
Did you have any objections to those additional requests that were made by Bernalillo County related to those areas, economic development and so forth?
No.
Okay, thank you for that. Would you turn to ABCWA Exhibit 2, please?
Okay.
And you talk about, at page 3 of that testimony, you talk about excessive acquisition premium and control premium. Do you see that language at line 17?
Yes.
Would you explain the difference between those two, please?
Well, the acquisition premium is the amount paid for the utility assets above their net book value at the time of sale. And the control premium is the amount paid above the current market price of the stock at the time of the sale. So there are little different calculations of a premium. One is more for rate making purposes. The other is just the stock premium that's paid at the time of sale.
And Mr. Garrett, you're talking about the price of the stock for PNM stock, not AGR stock, correct?
Right.
And how does is there any relationship between the acquisition premium and the enterprise value?
Well, what do you mean by enterprise value?
Well, that was going to be my question. I've seen that referred in the proxy statement and in other documents where there is a cash. Would you agree that there is a cash buyout in this acquisition?
Yes.
Okay, and that's in the tune of about roughly $4.312 billion, correct?
Correct.
Okay. And there's reference that's made to an enterprise value of being somewhere, and I've seen numbers, various numbers, in the vicinity of 7.8 to 8.3 billion dollars. And I'm trying to get clarity as to what that enterprise value means. But if you don't know, you don't know.
Yeah, I don't know. I didn't focus on that, didn't testify to it.
Okay, all right, thank you. All right, and would you now please turn to the exhibit 3, and that would be testimony in opposition to the second amended stipulation.
Okay.
And why, and let me refer you to page 5 of that testimony.
Okay.
And on lines 13 through 18, you talk about the rate credit, and that your recommendation is that it be between 126 million to 226 million. Do you see that?
I do.
And how do you arrive at those two with that range? I mean, that seems like a broad range. It's $100 million range.
Right. So the lower end is the price that was paid for the stock compared to the price of the stock at the current market price of the stock at the date of sale. So it was the amount paid, the control premium paid over the price of the stock at the time of sale. The other is over the average price of the stock over a longer period of time. And I can't remember exactly for that calculation what the number of days was, but it wasn't the price of the stock immediately before the transaction. It was over a period of time before the transaction.
So is that reflected on line 17 and 18 where you refer to the 30-day average stock price before the sale? Is that where that comes from?
That's it. It's 30-day sale. I couldn't remember whether it was 30 or a little bit longer, but yes,
Okay.
that's what it is.
And is that a normal metric that's used to calculate that 30-day
Yes.
period? Okay, thank you. Would you turn to page 7, please? And I'm looking at lines 13 through 17.
Yes.
And there you discuss the ability to recover the book value of the investment through rates. And you state there is no plausible way for the new owners to fully recover the additional $2.3 billion paid for the PNMR assets above book, other than through higher priced affiliate transaction for renewable energy projects. Is that a correct recitation of what you've listed there?
Yes.
Okay, there's a lot to unbundle, at least for me to understand that. To fully recover the additional $2.3 billion paid for PNMR assets above book. Question, does that apply to the PNMR assets that include both TNMP and PNM, or is that just for the PNM portion?
That's for the PNM portion.
Okay. And you have other than through higher priced affiliate transactions. So what would those transactions be?
You know, it would be affiliate transactions probably for renewable power, for renewable energy at higher than market prices.
Well, and you do have there on line 17 for renewable energy projects. And so is your assessment related to specific projects or just that these are replacement resources? Or I'm trying to understand what you mean by that.
Well, it could be either way. I mean, it could be replacement resources. It could just be purchase power agreements in the market. Either of those things. It's not to say that any of that would happen, but I don't see any way to fully recover the premium without help from affiliate transactions, because with a regulated utility, the utility can only recover the investment it's made in the assets that it dedicates to public service. That includes a reasonable return. But there's no other way to recover more than that. You can do it through cutting prices for a while or cutting costs, I mean. But at the next rate case, all of those savings get picked up and moved on to ratepayers. So it's very hard to recover a premium of that size, fully recover. And that doesn't mean it has to be. Premium can sit on the books as goodwill, and as long as the auditors don't make the utility write it off, it can stay there for a long period of time. And it can just be amortized slowly over a period of time to operating expense, which would lower your income, which might not be a problem either. But my statement was just that it can't be fully recovered through the rate setting process. That can't happen. And so either it doesn't need to be recovered, and that's okay, but if it's going to be fully recovered, it would be through some other way than the typical rate setting process.
Are you call to mind some questions that we had earlier? In fact, it might even have been last week with regard to goodwill. And are you aware that there's a proposal or there was testimony related to the establishment of holding companies for the goodwill separate holding companies, as I recall, for both the goodwill for TNMP and the goodwill for PNM.
Yes.
And so would that, how would that play into, this statement here that you have with regard to the ability to recover costs?
No, I don't. I mean, I don't think so. It doesn't really matter where the goodwill resides as far as fully recovering the acquisition premium. The acquisition premium can't be fully recovered through traditional rate setting process. That just can't happen. It may not need to be recovered. That may be okay. There may be other ways to recover it, but it won't be recovered through traditional rates.
So when you talk about renewable energy projects and recovering some of these costs, so that could be, for example, through a manufacturer. Would that be, as an example, through a manufacturer of equipment? Would that be one way of doing it? Where there's a subsidiary of some kind that produces, I don't know,
right, through
solar panels or something.
Right. Anything from an affiliate that's in a above market transaction could recover excess money that could be used to help offset the acquisition premium. So that's the concern. You know, the joint applicants have said that the ratepayers won't directly pay for the acquisition premium, as in many cases they're asked to do. They're not being asked to do that here, so that's a very good thing. My point was that the only risk then is the ratepayers indirectly paying the premium through affiliate sales, and so my point there was just that the commission needs to be aware of that risk and take steps to protect against it, either through a temporary ban on affiliate transactions or a lower cost of market rule, independent evaluator. But they do have to take precautions to just make sure that the premium's not being recovered indirectly through an affiliate sale.
And I was going to ask about an independent
evaluator. Mr. Albright, your time's up.
Oh, I'm sorry. All right. Thank you, Mr. Herring-Examiner. Thank you, Mr. Garrett, for your responses and your testimony.
Thank you.
All right. Let's move to Mr. Haverly. You've reserved 30 minutes.
Thank you, Mr. Herring-Examiner. Mr. Garrett, my name is Brian Haverly. I represent Avangrid and Iberdrola. How are you doing today?
Fine, thank you. Nice to meet you.
Nice to meet you, sir. Thank you. Mr. Garrett, have you
excuse me, Mr. Herring-Examiner, could we just ask Mr. Haverly to sit a little bit closer to the mic, coming through really soft and a little bit muffled?
Sorry about that. Is that better?
Thank you. Much better. Thank you.
Wonderful. Okay. Thank you, Mr. Albright. Mr. Garrett, have you reviewed joint applicants' rebuttal testimony wherein they agreed to many of the revisions to the second amended stipulation, which were proposed by NM Area and Bernalillo County?
Yes, I have.
Okay. And Mr. Garrett, are you aware that during this hearing, joint applicant witness Pedro Azagra Blasquez stated that joint applicants would be willing to provide additional benefits requested by the Water Utility Authority?
Yes.
And those additional benefits are $2 million of additional rate credits, $4 million of additional arrearage forgiveness, $1 million for—
Mr. Haverly, slow down.
Sorry.
Start with the $2 million in additional rate credits.
Okay, so $2 million in additional rate credits, $4 million of additional arrearage forgiveness, $1 million of contributions to create a supplemental scholarship program in the Albuquerque-Bernalillo County metropolitan area, and $1 million to create or enhance apprenticeships in local high schools and colleges. Are you aware of those?
Yes, I am.
Mr. Garrett, is it correct that with these additions that the joint applicants have agreed to, the Water Utility Authority no longer opposes the merger in this case?
Yes, that's my understanding, that with these additions, the Water Authority would no longer oppose.
Mr. Hearing Examiner, I have no other questions.
Okay, thank you. WRA, Ms. Beatles, do you have any questions?
Just one question, Mr. Garrett. I believe that you answered one of Mr. Albright's questions, that in many cases, ratepayers are asked to pay for an acquisition premium in a transaction of this nature. Do you recall that?
Yes.
By referring to many cases, you're not referring to cases at the PRC, are you?
No, and I appreciate the question, because lately, more recently, that is not the case. Most of the acquisitions and mergers now are being conducted without acquisition premiums being charged to customers. It was pretty common years ago. I can think of at least a couple, one recently, where the acquisition premium was charged to customers. But typically, it's in the last few years, they've not been.
And that's the case in New Mexico at the PRC with respect to those transactions that it reviews and hears.
Well, I don't know about it every transaction. I know that I am familiar with the El Paso transaction and this transaction, and neither one of them have an acquisition premium. The general rule is that acquisition premiums are not allowed in rates. Most states follow that, but I'm just saying that there are exceptions when there's sufficient synergies from the combining the two utilities, perhaps where an acquisition premium is allowed, because it will be recovered fairly shortly with the savings that are generated from the combination.
Yes, would you accept, subject to check, that dating way back to at least case number 2440, the PRC does not allow acquisition adjustments or premiums and rate base because the risk of the acquiring entity's decision to pay more than the depreciated original cost of an asset must be borne by the investor?
Well, I'm not aware of that language, but it sounds like the standard rationale for not allowing premiums, which is the general rule everywhere.
Okay, and you have no reason or basis to disagree with that statement?
No, it sounds very, very logical and normal.
Okay, thank you. That's all I have. Thank you for that clarification.
Okay, Ms. Zerd, you reserved 20 minutes.
I don't have any questions for this witness.
Mr. Getko, you reserved 30 minutes.
Our office doesn't have any questions at this time.
And Mr. Lesky, you reserved 5 minutes.
No questions, Mr. Hearing Examiner.
Okay. I also have no questions. Is there any redirect, Ms. Winter?
No redirect.
Okay. Well, Mr. Garrett, thank you. Thank you for your testimony and appreciate you being flexible.
Thank you so much. Appreciate it.
You're excused.
Thank you.
Okay. According to my notes, that's the last witness for today. Are any of the three that we have scheduled for tomorrow available this afternoon? Mr. Sandberg, Mr. Dauphiné, or Mr. Evans?
Mr. Hearing Examiner, I believe Mr. Evans would be available today. I'll try to reach him and confirm, but I think that's what he indicated yesterday.
Okay. Are you able to reach him in a short while?
I am texting him as we speak.
Okay.
He has indicated that he is available this afternoon.
Okay, great.
Can we decide, can we tell him when? So I make sure he's on board at the right time.
What about 1:30?
I think that should work.
Okay. And I understand that Mr. Dauphiné is not available until tomorrow. Is that right, Mr. Gould? I suppose that's true. And Mr. Sandberg is not available until tomorrow. Is that right, Mr. Nazi?
Yeah, till tomorrow morning.
Okay, all right. So we'll take up Mr. Sandberg first thing tomorrow morning and then follow with Mr. Dauphiné and then come back at 1:30 this afternoon and we'll deal with Mr. Evans. Okay, so thank you. We're in recess till 1:30.
Thank you.
Mr. Hearing Examiner, I was away from my desk. I understand that Jim Dauphiné is not available till tomorrow morning. He's working in another jurisdiction today.
Okay, that's fine. That's what we understood. Just wanted
Okay, thank you. Appreciate it.
Okay. All right, we're in recess till 1:30.
Okay.
Before we get started, Mr. Lee, if for any reason, I know there's been some difficulty during this hearing. I've listened to some of it between the witness, attorneys, and you being able to hear it. If you ever have any problems, I have my headphones with microphone.
I can hear you clearly now.
Okay. And if for any reason I ever talk too fast, or you think that I talk too fast, I'm from West Texas, so that'll probably be a first. And I'll be really proud, and I'd like it if you'd send me an email stating that I talk too fast, because I'll share it with all my friends.
I will do that.
Okay.
It may have some expletives in it, but I'll be happy to do that.
Okay, I'll try my best.
I'm ready when you are, Judge.
Okay, it's 1:30. Let's go back on the record. Mr. Borman, do you want to call your next witness?
Thank you, Mr. Hearing Examiner.
Wait, hold on. Let me just mention one thing. I'm sorry.
Sure.
I checked my email over lunchtime, and I noticed that the joint applicants have filed a request for administrative notice, and like to set a deadline for responses to that request on Friday, as I set the deadline this morning for the Attorney General's second notice of supplemental authority for responses to the Attorney General's second notice of supplemental authority. So Friday's the deadline for responses for both filings. Okay, Mr. Borman, go ahead. I'm sorry for interrupting.
Thank you, Mr. Hearing Examiner. Staff calls Evan Evans to the stand.
Mr. Lee.
Would you please raise your right hand? You solemnly swear the testimony you're about to give in the matter now pending should be the truth, the whole truth, and nothing but the truth?
Good.
Thank you.
Good afternoon, Mr. Evans.
Good afternoon.
By whom are you employed and in what capacity?
I am a principal consultant with Integrity Power Consulting, LLC.
And were you retained by the utility division staff to assist in the review of the application, I guess the joint application that is the subject of today's proceeding?
Yes, that and other matters that arise. Yes, sir.
Okay. And based upon the review, did you prepare or participate in preparing testimony regarding that joint application?
Yes, I did. I prepared it.
Okay, you should have two documents before you that are marked as Staff Exhibits 2 and Staff Exhibit 3. Do you see those?
Yes, sir, I do.
Okay, can you identify Staff Exhibit 2?
Staff Exhibit 2 is my prepared direct testimony. In this case, it was filed on April 2nd.
Was Staff Exhibit 2 prepared by you or under your supervision?
Yes, it was prepared by me.
Do you have any changes or corrections to Staff Exhibit 2?
Yes, I do. I have some changes that to my exhibit EDE 8, page 3.
Oh, thank you.
And it's in section B. The first one is in section B, Romanet 1. And in that second line, delete exceeds the standard by more than, and replace it with is in the worst. So that sentence now reads a penalty of $12 per customer served for each reliability index that is in the
$12
worst.
per customer.
$12 per customer served for each reliability index that is in the worst 10% for 2 consecutive years. The next adjustment is similar to that. It's in Romanet 2. Once again, delete exceeds the standard by more than and replace it with is in the worst. And the third and final correction is in Romanet 3. And once again, a similar adjustment. Delete exceeds the standard by more than to is in the worst.
And those are the sole corrections to staff exhibit 2?
Yes, they are.
And those corrections were made on the version of staff exhibit 2 that was uploaded to the Dropbox by staff earlier this week, or maybe last week.
Yes, I believe they were uploaded on the 9th.
Okay. If I asked you today the same questions as are set forth in staff exhibit 2, would your answers be the same as you have just corrected them?
Yes, sir, they would.
Okay. Are those answers true and correct to the best of your knowledge?
Yes, they are.
Do you adopt staff exhibit 2 as your sworn testimony in this matter?
Yes, I do, as corrected.
Do you also have staff exhibit 3?
Yes, sir.
Can you identify that document?
Yes, sir. That is my direct testimony or prepared testimony in opposition of the second amended stipulation that was filed on July 16th, 2021.
Was staff exhibit 3 prepared by you or under your supervision?
Yes, it was prepared by me.
Do you have any changes or corrections to staff exhibit 3?
Yes, I have similar corrections to those in to staff exhibit 2. And those changes are on page 6, the first one is on line 12. And you delete the words exceeds the standard by more than to and replace it with is in the worst. The second correction is similar, and that's on line 14. Once again, you delete the words exceeds the standard by more than and replace it with the words is in the worst. The final correction is on line 16. Once again, you delete the words exceeds the standard by more than to is in the worst and replace it with the words is in the worst. And those are all my corrections.
Okay, thank you. If I asked, well, were those corrections made on the version of staff exhibit 3 that was uploaded to Dropbox?
Yes, sir, they were.
Okay. If I asked you today the same questions as are set forth in staff exhibit 3, would your answers be the same as you have just corrected them?
Yes, they would.
And are those answers true and correct to the best of your knowledge?
Yes, they are.
Do you adopt staff exhibit 3 as you have corrected as your sworn testimony in this matter?
Yes, I do.
Thank you. At this time, I move admission of staff exhibit 2 and staff exhibit 3.
Any objections? Hearing no objections, staff exhibit 2 and staff exhibit 3 are admitted.
Thank you, Mr. Evans. I pass the witness.
Okay. First on the list is the Water Authority. Ms. Winter, you reserved 5 minutes.
No questions for this witness.
Okay.
I'm sorry, who said that?
Nan Winter for the Water Authority.
Okay, next is Mr. Albright. You reserved 10 minutes.
Yes, Mr. Hearing Examiner, thank you. Good morning, or good afternoon, Mr. Evans.
Good afternoon, Mr. Albright.
I'm with J. Albright Law LLC, and I'm here on behalf of the county today. It's their outside counsel. My questions are going to focus on Staff Exhibit 3. So if you want to turn to that, that was the testimony in opposition to the second amended tip.
Yes, sir, I have it.
Okay. Let me ask a preliminary question regarding that. Had you read the testimony of Ms. Maureen Reno in this case related to performance and metrics?
I did. I read it some time back.
And do you understand that those penalties that she proposed came from similar penalties that exist in Maine? Are you aware of that?
I'm aware of it. Just that's what was said.
In a general sense, correct? That you're just aware of that in a general sense.
Yes, sir.
Okay.
I am.
And that she deferred to the metrics and criteria that you and staff come up with, you on behalf of the staff of the PRC come up with in this proceeding, correct?
Yes, sir.
Okay. All right. With that, and because my time is limited, I do have a question as to why these metrics are being applied to PNM in this proceeding and not for other utilities.
Thank you for the question. Yes, as I've said in my testimony earlier, the reason why these metrics are being applied is in order to satisfy the standard or the requirement that there will be no diminishment of, or that customer service will not be diminished. These standards would provide assurances that that requirement is met.
Do you think similar criteria should be developed for each of the other IOUs in New Mexico?
I think they can be. I would leave that to staff. I know that similar reliability standards and penalties are required in other states. One that I'm most familiar with is the state of Texas, and they have standards established similar to those that I have delineated in my testimony.
So, and I noticed you do have reference to it, but so why wouldn't you do this as part of a rulemaking proceeding as opposed to levying them here as part of the stipulation?
That is a good question. The reason why is because in a rulemaking, you're going to be looking at different issues, but there is, that I know of, there is not an obligation where a requirement established for utilities restricting a diminishing of customer service. This is something specific to an acquisition or merger.
Okay, well, let's assume for a moment that the commission does not approve the acquisition or merger. If that occurs, would you recommend that these penalties and conditions still be applied to PNM?
No, sir.
And then why not? if they haven't met the performance standards over the previous whatever years it is.
Because as I said earlier, that is one of the requirements that have been previously established for approval of a merger, is that there will be no assurance that there will be no diminishment of services. Not saying that the PRC staff and the commission may not choose to establish standards and impose penalties on all the utilities, electric utilities in the state of New Mexico, but there are no such standards now. And the only requirement that I'm addressing is a requirement that assurance that customer service will not be diminished.
Okay, you also make reference to rule number 36 of the amended, second amended stipulation, and a couple of the provisions in there, such as, and I'm referring to page 19, if you want to turn to page 19.
Yeah.
And you refer that to a couple of provisions that you find are acceptable, and then one or two provisions that are not. And just to cut to the chase, how do you envision these changes, if they're accepted, if they aren't accepted, being reflected in some kind of final amended stipulation that gets presented to the commission?
Well, if there's a final either recommended decision or a stipulation, I would say that they would have provisions similar to that I included as my attachment or exhibit EDE 8 to my original testimony, and that would be attached to a recommended decision or stipulation.
So are you anticipating that the hearing examiner will incorporate different aspects of these into a stipulation, or that the joint applicants will revise the stipulation? And again, just to put it in context, I'm trying to figure out how I'm going to brief the county commissioners on what's going forward at this juncture. And I don't know how that's going to work.
That would be my expectation. I have previously, I was involved and responsible for case management for the American Electric Power Central and Southwest merger that was consummated June 15th, 2000, and or was completed. In that merger, they had specific reliability and customer service requirements that were included in the final order, the stipulation and the final order that was approved in a number of the states involved, because I was particularly involved in 4 states, but they also had the eastern side, which had 7 states. But in the 4 states of Texas, Oklahoma, Louisiana, and Arkansas, reliability was an issue that was addressed in those stipulations and orders, particularly in Texas and Oklahoma. The one in Texas, matter of fact, was instituted before they put in the current reliability standards as they have today with the requirements and the penalties. It was approved beforehand, before this has gone into place. They'd reached an agreement prior to that rule going into place.
Hey, Mr. Hearing Examiner, I have no further questions for Mr. Evans. And Mr. Evans, I thank you for that, and also for the explanation. Very, very helpful. So thank you very much for your testimony.
Thank you.
Okay, next is WRA Ms. Beatles, you reserved 5 minutes.
I have no questions.
Okay, next then is the Attorney General. Mr. Getko, you reserved 30 minutes.
Yes, but we do not have questions any longer. Thank you.
Okay. Mr. Leskey, you reserved 5 minutes.
Yes, Mr. Hearing Examiner, thank you.
Go ahead.
Good afternoon, Mr. Evans. My name is Justin Leskey. I represent IBW Local 611, the International Brotherhood of Electrical Workers.
Good afternoon, Mr.
And the only thing I wanted to ask you about is on your July 16th testimony, that's Staff Exhibit 3, pages 20 to 21.
Yes, sir.
In that testimony, you had talked about in lines, what I'm looking at are lines 20 and 21 of page 20, and continuing on to the next page, you had talked about the issue in the Second Amendment stipulation about targeting 20 jobs to be electric service business unit craftsmen. Do you recollect that testimony?
I am looking at it. Yes, sir.
And you state, looking at page 21, lines 3 and 4, you state that although this is encouraging, the joint applicants did not specifically commit to hire 20 electric service crafts personnel. Do you see that?
Yes, sir, I do.
Okay. You mentioned you had reviewed Ms. Maureen Reno's testimony, the witness for Bernalillo County.
Yes, I did. Primarily that addressed mine.
Okay. Do you recall there was a section in her testimony where she had mentioned revising this language to state that at least 20 of these jobs will be electric service business unit craftsmen. Instead of targeting 20 of these jobs, it would say at least 20 of the proposed jobs would be electric service business unit craftsmen. Do you recall?
Sorry, instead of targeting 20 jobs, it would say
at least 20 of these jobs will be electric service business unit craftsmen. Do you recall that testimony from Ms. Reno?
Generally, I have refreshed my memory, but I generally remember that discussion. Yes.
Would you support that language change?
Yes, I'm concerned with the language that says target.
Okay.
You know, I go out to the shooting range all the time, and some folks' aim sure isn't as good as others. And so if I'm a professional and I'm telling my client that this is something that they should rely on, I had better make sure that my professional liability is paid up and is a pretty good professional liability insurance. So I wouldn't use the word target unless I expected them to miss it.
Okay. So just to summarize, you would support the language if it was changed to say at least 20 of these jobs will be electric service business unit craftsmen?
Yes.
Okay. Nothing further, Mr. Hearing Examiner. Thank you, Mr. Evans.
You're welcome. Thank you.
Okay, Mr. Haverly, you reserved 10 minutes.
Thank you, Mr. Hearing Examiner. I do not have any questions for this witness.
Okay. Mr. Alvidrez, you reserved 30 minutes.
Yes, Your Honor. Thank you very much. Hello, Mr. Evans. My name is Rick Alvidrez, and I'm a lawyer for PNM and PNM Resources in this case. And I want to ask you a few questions, beginning with your initial direct testimony, if you can locate that for us.
Yes, sir.
And I was just looking at your background a little bit. I know you've worked in the utility industry a long time. In terms of your formal education, you have a BBA in finance, is that correct?
Yes, I do.
And I didn't see anything, you don't have any other degrees besides your BBA degree, is that correct?
No, no other degrees.
And it did not appear that you had any education in any engineering sciences, is that correct also?
No, I started out as electrical engineering and continued to take electrical engineering required courses in my undergraduate, but I got I switched to finance and I got my degree. I just couldn't see myself doing electric schematics for the first 10 years of my career. And so I went to something I thought I'd like a little bit better.
You got a finance degree and never got your engineering degree. Is that correct?
No, I did not.
And then you went to work for West Texas Utilities Companies. Is that correct?
That is correct.
And I was looking at page 3, line 3. It says you held a variety of positions, analytical, consultant, management positions in rates, regulatory services, load research, marketing, and business development. Are those the areas that you worked in there?
Yes, within the Central and Southwest system. Yes.
And then you went to work for the C.H. Guernsey and Company, now known as Guernsey Associates.
Yes.
You were a consultant, is that correct?
Yes, I was.
And so looking at line 11, it says that you, not line 10 actually, you provided consulting services to electric utility industry clients in a variety of areas, including regulatory compliance, integrated resource planning, electric utility cost of service issues, rate studies, financial analysis.
Integrated resource planning.
I'm sorry, yes. Electric utility cost of service issues, rate studies, financial analysis, economic feasibility analysis, retail electric choice, and wholesale power supply contract negotiations. Is that the list of the areas that you consulted in?
That's a general list, yes.
Okay, and then you went to El Paso Electric Company, right?
That is correct.
And you established the company's regulatory case management and energy efficiency utilization departments.
That is correct.
Right? And in that, in your position there, you headed up EP's energy efficiency and utilization, economic and rate research, regulatory case management, and regulatory accounting departments. Is that right?
That is correct.
And you've, in your resume, you've attempted to, or your testimony, you've attempted to provide an accurate list of things that you've been involved with, right, in your career?
Yeah, some. I've had a 41-year career, so I've been involved in a lot of things, but this provides a general scope of work.
Okay, and then in January 14, you went to work for Xcel Energy as Vice President of Rates and Regulatory Affairs for SPS, is that right?
Regional Vice President, sure.
So in terms of Regional Vice President, do you have oversight in Texas and New Mexico?
And FERC.
Okay, and you also had FERC, okay. And then in March, you became Director of Regulatory Pricing for SPS?
That's correct.
And was that a promotion?
No, it was not.
Was it a demotion?
Yes, it was, essentially. It was a result of a reorganization, but yes, that was essentially a demotion.
So looking at your job duties there, you established some regulatory programs relative to compliance with legal and regulatory requirements with the Public Utility Commission of Texas, the NMPRC and FERC, as you talked about, is that right?
Yes.
And then you oversaw the regulatory filings for the state commissions and FERC, is that right?
That is correct.
And then you were in charge of regulatory activities to establish and maintain relationships with regulators, essentially, is that right?
That is correct.
And then you directed the cost allocation and pricing functions for SPS, correct?
I'm sorry, pricing functions?
Yes, pricing functions for SPS. Is that
That is
correct? Now, I know you've been in the utility industry a long time, but I did not see anything that indicates that you have had any direct transmission and distribution, or T&D, experience. Is that correct? Similar to what Mr. Fridley has?
No, I've never been a transmission and distribution engineer.
Okay. And the testimony that you have provided in this case deals with transmission and distribution issues, does it not?
It is relative to reliability and the reliability performance of primarily your distribution system.
Okay. So there's been some confusion, at least on my part. When staff's attorney was cross-examining Mr. Fridley, and did you have a chance to watch that?
It was broken up a little bit, but I pretty well got most of it.
Well, Mr. Fridley made reference to what he perceived as staff's opinion that PNM's reliability performance is substandard. And let me, get your clarification on this point. Is it staff's position that PNM's current reliability is substandard in some way?
Well, I don't remember Mr. Borman making that statement. It is not my position that their reliability is substandard at this point. The concerns I raised was in diminishing of your system reliability performance metrics. You've asked a lot of questions about my background. However, and whether or not pointing out I was not a transmission or distribution engineer. However, I was involved in the rulemaking that establishes system reliability metrics in the state of Texas from a regulatory standpoint. And I've reviewed and have developed the SAIDI and safety calculations and filings for both electric cooperatives as well as investor-owned utilities, not only in the state of Texas, but also in preparing them for the state of Oklahoma. So I have experience, and I know when I'm seeing diminished reliability, and that's all I spoke to, was that it has been declining, and my testimony is relative to ensuring there is not a diminishment of customer service reliability.
Do you have Mr. Fridley's testimony handy, his July 29, 2021 rebuttal testimony?
Let me pull it up.
And I'm going to ask you to look at an exhibit to that testimony. It's JA Exhibit TF1.
Okay, and I'm trying to look through on the Dropbox. Fridley's, what, do you remember what exhibit number that is? The rebuttal
Yes,
testimony? Is that the rebuttal
Yes, sir,
testimony?
rebuttal testimony.
Okay, I'm pulling it up now.
But his July 29 rebuttal testimony.
That's correct.
And for the record, is that JA Exhibit 35?
It's 35, yes, sir.
Okay, thank you.
And let me ask you a few other questions. As I understand it, you pulled reliability data concerning PNM from its annual filings with the commission. Is that correct?
That's correct.
You gathered 15 years, 2005 to 2019. Is that correct?
All the years that were available at the time I filed my direct testimony, that was all that's available. I did update in my rebuttal testimony for 2020.
Okay. Did you do the same thing with regard to either SPS or El Paso Electric?
Yes, I looked at those too.
Okay. So you've seen their reliability metrics, right?
Yes, I have.
And as I understand it, a concern of yours is the trend lines for PNM suggest to you some diminishing reliability performance. Is that a fair characterization of a concern you've expressed in this case?
That is fair. And the concern is that customer service would be diminished after the merger. So there's additional factors.
All right, let's go ahead and look at JA Exhibit 35, I'm sorry, and look at the exhibit TF2. Do you have that?
Yes, I have that.
Not TF2, TF1.
You want TF1? Okay.
Yes, sir. And do you understand that to be a comparison among PNM, El Paso Electric, and SPS in terms of their SAIFI, S-A-I-F-I, and SAIDI, S-A-I-D-I performance from about 2005 to 2020?
Well, it is not a comparison. It just lists their performance for 2005 through 2020. Because
sorry, go ahead.
There is no comparative analysis or comparisons. It just is, it presents it. But yes, I have that.
And they show similar trend lines, right, for all three utilities. That is, the trend lines are increasing, correct?
To varying extents, they're all increasing.
Now, El Paso Electric just was the subject of a merger transaction that was approved last year, 2020. Are you aware of that?
Yes, I am.
And there was no similar proposal from staff with respect to having a penalty system in place, despite the fact that their trend line in terms of reliability is in an upward trend, right?
I do not believe there was one.
And you indicated as a clarification, at least a clarification to me, that what you're trying to do is make sure that PNM's performance doesn't diminish after the merger. Is that right?
There will not be a diminishment of customer service as a result of the merger or after it. That would be correct.
Okay. And in terms of your proposed penalty program, and it is a penalty program, right? That's what you're proposing is some penalties if PNM doesn't achieve certain metrics after a couple of years, right?
Well, no, that's part of it. It's reliability with penalties. But if you maintain quality reliability, there's very little, risk of penalty. It's only if it diminishes based upon what I provided here. My recommendation, would there be significant penalties?
But in coming up with your benchmark, you're not using the latest 5 years, for example, of PNM's performance, right?
No, that is correct. At the time that it was developed, I used up through 2017. And the reason why I did not use 2018 and 19, as I said in my direct testimony, where they appeared to be outliers because they were significantly higher. And if you look at what I did provide in my testimony, the 5-year average up through 2017 would be higher than any 5-year average for the period beginning in 2015 up through those years. So I picked what I thought was representative, and I gave PNM the benefit of the doubt that 2018 and 2019 were aberrations and not something that PNM would want to set as the norm or the standard for future reliability.
But if you look at PNM's current performance, in order to meet your average that you are proposing, it would actually have to increase its current reliability, correct?
And explain to me how it would have to increase its current reliability?
Well, according to your reliability standards, in 2019, PNM would have been outside compliance, right?
And like I said, that was an aberration year. And if you look at my exhibit EDE 5 from my direct testimony, I show no, make that was wrong, because this is EDE 2, where I highlight what the rolling 5-year average is. That is what the 5-year average is, but I didn't apply a penalty until they exceeded the 5-year average by 10%. So they would have had had to hit safety at 0.89 and SAIDI at essentially 87 minutes, or nearly an hour and a half a year with customers out. And that is higher than they had experienced in any year before 2017, assuming that 2018 and 19 were aberration years. And when you look, when you look, that proves to be true when you look at my EDE 1SO. Those penalties, 2021 for safety, PNM met that requirement, and then for SAIDI, they were a little bit above that requirement, but that is just the first year. And the requirement is that they've got to exceed it for 2 consecutive years before any penalty occurs. So no, I would not say that they would be automatically be subject to penalties for exceeding those SAIDI and safety requirements, particularly with what, as Mr. Fridley discussed, with the Wired for the Future program that they expect will help to improve the reliability. So therefore, that provides even further assurance that they should be able to meet these goals.
Well, you've read the testimony of Mr. Fridley, right?
I did.
And it's his professional opinion that the company would be in violation right out of the gate because of the years you've selected, right?
That's his opinion, and I disagree.
He's the one that operates the system at PNM, right?
Yes, he is, and I still disagree. I mean, I have worked with reliability metrics for 6 different investor-owned utilities, and I have at least half a dozen electric cooperatives and worked with them. So I will say it's his opinion as an employee of PNM that it would not be able to meet these requirements right out of the gate. It's my opinion that I don't see that happening the first year that any penalty could go into effect would be for the year 2023. And especially with all that, as Mr. Fridley discussed, the Wired for the Future program and the steps they're taking, there is no reason why they should incur a system-wide penalty.
Well, you say that the penalties wouldn't accrue until 2023, but in fact, you would start assessing compliance beginning immediately. It would be, if this deal closed at the end of 2022, you'd be looking at, but would you be looking at 2021 and 2022, or would you be looking at 2022 and 2023 and then do the assessment in 2024? How is your proposal set up?
My proposal would be is that you will file 2021 data in 2022. There's no penalty. You will file 2022 data in 2023. If you do not meet the standards or you exceed your safety measures, exceed the threshold, then you would incur a penalty in 2023 based upon your 2021 and 2022 performance.
That is what I was driving at. And so it's a backward look, and they're looking at how did you perform in 2021 and 2022 when the penalty would accrue, right?
That is correct. In 2023, any penalties would be assessed for non-performance for 2021 and 2022, and it requires both years.
Understood. So, 2021 is almost in the books. There's not much PNM can do about its performance so far for 2021 in terms of trying to comply with this proposal if it does get adopted, this penalty proposal, right?
Well, I mean, if they're waiting till now to look at the reliability of their system, then I've got some concerns for how they're managing their system. This is something that distribution system planners and those who operate and maintain a system should always be doing on an ongoing basis, is ensuring that they're maintaining reliability and doing everything possible to improve reliability. And so to say that there's not much of the year, it's August. You still have the fall and winter storms. But I'm going to tell you, if you're just starting now, yes, you're already behind the ball. But my question is, what has happened for the last several years when you could have been looking at reliability? And that is what system planners, all the system planners that I have worked with in the past are always looking at what has been our performance this year and previous years, and where do we need to take steps to improve our system. And then for your operations personnel, where do we need to position our people, and how do we need to staff to address the service reliability issues that we're seeing?
And Mr. Fridley testified that he does that, in fact, right?
Yes, he
Reliability and
did.
safety are key things.
I'm sorry, I didn't hear the question.
Mr. Fridley testified that he does that reliability and safety are key things that he looks at in terms of managing the operations around PNM's distribution system. Now, with regard to El Paso Electric and SPS, I mean, I take it you haven't done any analysis to try and assess why the three IOUs show a trend line of increasing. that correct? You didn't look at SPS or EP with respect to why their trend line is increasing, right?
5 minutes, Mr. Alvidrez.
Thank you.
No, that my engagement was to look at this merger and issues relative to customer service in this merger. I have looked at their trend line, SPS's trend line in Texas, and I have looked at EPE's trend line in Texas, and we'll say that those are pretty static. They're not increasing. They don't have the same types of increases that we're seeing in this graph for PNM.
Where all three of the IOUs are showing an upward trend, right?
In the New Mexico filing, they all three have shown. I will say in 2019, there was a significant drop for EPE, and then there was a significant drop for SPS in 2020.
And PNM
I mean, for PNM, I said SPS, meant PNM.
Right. So let me ask about, I guess is your system, penalty system, based loosely on the Texas system that you described?
The requirements are based on the Texas system, the service requirements, but the penalty is not.
Okay. But that Texas system that you talked about was done in the context of a regulatory, a rule-making proceeding, right?
The one that is in place right now was a result that is in place right now was in a rulemaking from back in, I believe is 99 or 2000. And as I said, though, the AEP companies had agreed to reliability standards with the parties before this rulemaking in Texas was completed.
Now, as I understand it, your penalties are based upon your estimate of, yes, a 10 basis point reduction of PNM's ROE. Is that right?
No, 10 basis point reduction of their distribution related return.
So just related to the distribution
That's
assets,
correct.
Is that right?
That is
Okay,
correct.
Thank you for that clarification. And according to your calculation, it's $340,000 on the SAFE measure, right?
Yes, I think I provided those calculations and work papers, but yes.
And so I'm clear, your proposal only goes one way. That is, you can only get penalized. Isn't that correct?
That I do not have bonuses for performance that no, it does not contain a bonus provision.
And the way you propose that these penalties be distributed once they're paid is rate credit to customers. Is that right?
To distribution voltage customers, yes.
Do you know what the requirements are under the New Mexico Public Utility Act with respect to penalties?
I'm not really sure what your question is, what the requirements are relative to penalties.
Yes. Do the penalties, do you know what the penalty statute is under the New Mexico Public Utility Act?
I do not know. No.
And do you know whether that penalty statute allows penalties to be sent to customers, penalties that are collected to be sent back to customers?
No, and as I referred to them, is you refunded. Penalty may have been an inartful word, but you know, I do not know if that is a requirement or if there's any limitations on paying refund to customers.
Well, I mean, I'm not using, it wasn't me who started using the word penalty. You used those words, that word in your proposal, right?
And I said the combined penalties will be refunded to all of PNM's retail distribution customers.
Right, so they are penalties. So just so we're clear what we're talking about.
Yes.
Do you know whether your penalty program would even be legal under the New Mexico Public Utility Act?
I object. It calls for a legal conclusion.
Overruled.
Well,
I can't make a legal opinion on that. I can't give you a legal opinion. I do not know.
okay. Thank you very much. I appreciate it, Mr. Evans.
Okay, Mr. Evans, I have one question for you. It relates to your one of the exhibits attached to your April 2nd direct testimony.
Yes, sir.
It's exhibit EDE-9.
EDE-9.
It's page 1 of 1.
Yes.
I was trying to understand how you arrived at your penalty calculations, and in particular, I was looking at line number 10.
Okay.
It says impact of 10 basis point reduction on ROE, and you have 0.05%, and your reference is line 18 times 10 basis points.
Well, I have an extra 1 in there. That should be line 8. Thank you for finding that error. In other words, 10 basis points, since your equity is roughly only your 50-50 equity debt, so 10 basis points would be a 5%, would be a 5 basis point reduction to your rate of return.
All right, well, thank you. That clears that up. That's all I had. Is there any redirect?
Very briefly, Mr. Hearing Examiner. Mr. Evans, you were asked some questions by Mr. Alvidrez regarding staff's position in the El Paso Electric acquisition on Jupiter in case number 19-00234-UT. Do you recall that discussion?
Yes, I do.
Okay, and I think he asked if
Did you say Sun Jupiter?
Sun Jupiter, yes.
Thank you. You broke up.
I'm sorry. And I think he asked whether staff made a similar recommendation regarding reliability metrics in that case. Do you recall?
Yes.
Okay. Were you retained by staff to assist in evaluating the El Paso acquisition in that case?
No, I was not.
Okay, thank you. I have no further questions.
Okay. Thank you, Mr. Evans. Thanks for your testimony. You're excused.
Thank you very much. Y'all have a good
Thanks
day.
for being flexible, moving up like this.
Thank you.
Okay. As far as I know, that concludes the witness testimony for today. Tomorrow we have Mr. Sandberg up first, and then Mr. Dauphiné. Is there anything anything else we need to talk about this afternoon?
Mr. Hearing Examiner Peter Gould, we looked at the number of minutes for Mr. Sandberg, and they're quite considerable. So we have advised Mr. Dauphiné to be available after lunch. If you want us to have him go earlier, we can. And in that light, we wanted to waive the 30 minutes that we had for Mr. Sandberg. And if anybody else could waive or could give us an idea that they're intending to waive, we'd have a better idea, so there wouldn't be a gap with respect to those two testimonies. just want to make sure that we move smoothly through tomorrow.
Well, is anyone intending to waive any cross-examination for Mr. Sandberg? I don't hear any takers on that.
It's likely that WRA will, but I won't know for certain until first thing tomorrow morning.
Yeah, Mr. Gould, I think it's pretty difficult to determine now how that cross-examination is going to go, how long it's going to go. So I suggest that Mr. Dauphiné be ready to go probably late tomorrow morning.
That'll work. Thank you so much. And we'll make sure he's on the Zoom call so he's ready in enough time.
Okay, thank you.
And one more note, my co-counsel will be handling the hearing tomorrow, and I'll be on the YouTube.
It's
Okay.
about time.
Well, I figured that would be good news, but don't be so enthusiastic.
Okay, we're in recess now till 9 a.m. tomorrow morning. Thank you.